All right, good morning, everyone. I'm Judge Jackie Powell. We have lots of sleeping persons over there. This is first appearance court, and today I will let you know if I've determined probable cause, and then we will talk about release conditions. Please note that good morning. Please note that today is not your trial date, so I encourage you not to talk about your case on the record. Everything in this courtroom is being recorded and can be used against you at a later time. If you wish to speak on the record, you may need to speak with your attorneys. If you're represented by the Public Defender's Office, I do have an attorney here in the courtroom with me, and there's also an attorney over at the main jail. And those of you at the other facilities are able to speak with them via phone. If you are represented by private counsel, your attorney will come to the courtroom, and if your attorney's not here, you can also let me know, and we will see how we can facilitate that process. Also need to let you know that in the courtroom, we have the attorney from the state attorney's office, as well as we have confinement status, pretrial supervision, and the clerk of courts. And all these persons are here to help facilitate this morning's hearings. If there's any additional information that we may need, they may be able to provide that information. So as I call your name, I'm going to ask you to come up. There are a few persons that the jail has asked us to call out of turn, so I will call those first. And so let's first address Antoine Henderson.
Mr. Henderson is present at the main jail, Your Honor.
Good morning.
Good morning.
All right. Mr. Henderson, you're before the court this morning for charge one is obtaining a controlled substance by fraud. The court finds probable cause. And,
Yes, Your Honor. Mr. Henderson is a lifetime resident of South Florida. He's a graduate of MacArthur High School. All of his family resides here. He does have a job. He's a plumber. He does have a 6-year-old son who lives with him. He is currently being taken care of by a friend. He does have money, but he does not have access. He's advising me this is his first felony. We'd be requesting a pretrial release, Your Honor.
Just want to advise the court, I'm showing 5 times in the past he's been arrested for failing to appear in court.
And when was the most recent?
May 21st of this year.
All right.
Judge, he's advising me that he moved and did not get notice of court dates.
I took care of it.
There's also a $2,000 warrant out of Dade County for failing to appear on a possession of cannabis currently.
All right, based on the allegations that are before the court this morning, I am going to leave the bond at $1,000, okay? All right, good luck, sir.
Thank you, Your Honor.
All right, Jason Cuddy.
Judge, we're requesting a phone, access to your cell phone?
No, access to the phone, I can call the Bell's phone.
So he's requesting an order for access to the phone?
I'll sign the order.
Thank you, Judge.
Jason Cuddy.
Mr. Cuddy is present at the main, page 30.
All right, Mr. Cuddy, you're before the court this morning for one count of aggravated battery on a person 65 years or older, and the court finds probable cause.
Judge, Mr. Cuddy is advising me that he was in front of his division judge yesterday and the bond was set at $10,000 with pretrial release. He also indicated he's going to be hiring private counsel.
Is that correct? All right, so that's been confirmed, so the court finds probable cause, and with all the conditions that his division judge set. What was that, 10,000 with pretrial?
We did the other court date correctly.
So then he doesn't need that status hearing. Oh, good morning, Dante. He doesn't need that status hearing for tomorrow then, because he's already been before his division judge. All right, Brian Trala.
So, Judge, just clarify, you're deleting the status conference for tomorrow?
That's correct.
Thank you.
Brian Trolla,
Requesting a photo order.
I'll sign that order. Mr. Trolla is before the court on aggravated assault with a deadly weapon without intent to kill. And number 2 is battery on an officer or firefighter. The court does find probable cause.
Your Honor, the state would be seeking a $5,000 bond on count 1, $1,500 bond on count 2. No victim contact. I'm sure the court is familiar with Mr. Trolley. He's appeared before the court numerous times, as recently as 2 weeks ago for a capias on a municipal ordinance. He's got a resisting without violence and theft from earlier this year, resisting without violence, disorderly conduct from February of this year, 2017 burglary, conveyance, and felony theft, 22 months state prison as a habitual offender, 2016 battery on a law enforcement officer, 22 months state prison, habitual offender, felony battery due to priors, 2015, just multiple priors before that, Your Honor, an aggravated battery, great bodily harm, possession of firearm by convicted felon, 2010, 3-year state prison, just in numerous incidents recently all around the Fort Lauderdale beach area.
Your Honor, Mr. Trala advises that he cannot afford any bond. He currently resides at Third Step Recovery, and he's in the process of obtaining SSI. I would ask the court to release him pre-trial custody to Third Step.
And do we know that there is room for him at Third Step?
He's nodding his head, Judge.
Well, I'm not gonna do that unless I'm sure that that's gonna happen. Mr. Trolla has been before me several times and it's usually these similar types of crimes, so unless we know for sure, at this time, I am going to impose a $2,500 bond on count 1 and $1,000 on count 2. No victim contact until further order of the court.
Judge, could we hold that order in abeyance, reset him for the afternoon, maybe try to confirm whether or not there's a place for him at Third Step?
Your Honor, my only concern is, and that's why I think maybe a more thorough hearing is necessary, if he was already in Third Step, this occurs, he clearly wasn't there when this happened, he's under the influence of alcohol, matter of fact, he's using the bottle of alcohol that he allegedly was drinking from as a weapon. My concern is how effective is the treatment that he's
All right.
supposedly receiving.
I'm gonna leave the bond in place, all right? Christy Weisbecker?
North Broward.
You gonna try to call her?
No. She's not going to let you up to Third Step. You have to postpone.
All right.
So address it with your division judge.
Ms. Weisbecker, you're before the court on 1 count of possession of MDMA. Number 2 is possession of heroin. Number 3 is a misdemeanor capias on a municipal ordinance violation. That charge is also possession of paraphernalia. So the court finds probable cause. And does anyone wish to be heard as to bond?
Judge, I know that they were going to take her back. She has asked me to request pretrial release. She has been a resident of Florida for 11 years. She's been living for the last 9 years in the same location. She lives by herself. She's been working at the same job in construction for the last 5 years. She pays approximately $140 a week in rent. She does not have any finances saved up or any money with which to post a monetary bond, so she has asked me to request a pretrial release of the court.
Your Honor, and I just would bring to the court's attention, in 2016, she was put on pretrial for a prostitution case, and apparently she never reported to pretrial.
Yes, ma'am. Ms. Weisberger, where do you live?
Pompano.
This is Broward Outreach right here.
Whereabouts in Pompano?
Collier City.
Collier City. Your Honor, I can tell you that for over the last 3 months, I've seen this individual walking the streets in Collier City with no permanent place of abode.
Okay, does she have priors other than this, I know she's got this municipal ordinance.
She has the prostitution, Your Honor. Frankly, unless you have notes, since it's a medical reset, I'd have to
No more flap.
enter her information in the system again. They don't, the
Right,
medical
this was
resets don't.
reset, twice, I guess.
Yeah, unfortunately, in my database, the medical resets don't carry over from day to day.
Coming in
Okay.
here, all strung out and
So I can
hungover.
get you the information. It's just gonna take me a moment.
So are there prior drug charges?
No, ma'am.
Well, I'm not asking you, I'm asking pretrial, so.
Yeah, don't say anything, Ms.
Let me hear
Weisbecker.
from them. All right, this time I'm gonna leave the bonds in place, and it looks like, Ms. Weisbecker does have court before her division judge tomorrow, okay?
And again, Judge, could we delete her from the second look
And,
docket?
if the clerk could delete her from the second look, docket this afternoon, thank you.
Good luck, Christie.
All right. Marche Matthews,
Present at the main jail, Judge. Stand to my right, please.
all right. All right, Miss Matthews, you're before the court this morning for one count of aggravated assault with a deadly weapon, it's domestic, and number two is a misdemeanor capias, and the court does find probable cause. I'll hear from the parties as to bond.
One moment, Your Honor. See that? I'm just trying to see who gets who. Let's see. Excuse me, Your Honor. Your Honor, I'm going to be requesting a $3,500 bond, no victim contact. Ms. Matthews has a prior arrest in 2017 in Dade for domestic violence. The charge was dropped. Because it's out of date, I don't know who the alleged victim in that case was.
Okay,
Your Honor, Ms. Matthews is a lifetime resident of South Florida, graduate of Miami Norland High School. All of her family lives down here, so she has strong familial ties. She has 3 children, 2 years, and a 3-month-old who she is currently nursing. They are with the father, who is not the alleged victim in this case. She's advising that her children also have medical issues that she has to attend to. She was not aware of the Novella DL case, count 2, and I would point out to the court that there is the alleged victim in this case does not wish to prosecute. So I'd ask the court to consider pretrial release at this time.
all right. Based on the allegations and the probable cause affidavit, and the report does say that the victim does not wish to prosecute. I am going to, I'll release Ms. Matthews to pretrial supervision, but I'm also ordering no victim contact until further order of the court, okay?
Thank you, Your Honor. That for both charges, Your Honor?
Yes. All right, our Spanish interpreter is here for who?
On page 8 of the court's docket, Miss Acosta, and she is in North Broward. Oh, I'm sorry, she's in Paul Ron, Judge.
All right. Have I went too far? Huh? She's sick. Yes. All right, Mr. Costa. All right, if you give Costa, yeah. All right, Verde Acosta,
Paul Ryan, Your Honor.
Paul Ryan. All right, Mr. Costa was on the docket yesterday.
Yo aconsejaba al calendario judicial ayer.
Is this for something new today?
¿Es por algo nuevo hoy, señor fiscal?
Mr. Costa, you're before the court for one charge of petty theft,
Señora Acosta está ante el tribunal hoy por un cargo de hurto menor
and there is a felony violation of probation with a no bond hold.
y hay una violación de probatoria de un delito mayor sin fianza.
Yeah, I
Su
thought,
fianza ha sido pagada, sí, la del delito menor, del hurto menor.
Your Honor, I think what happened was that she technically did not have a first appearance on count 2.
Creo que lo que pasó, señora, que técnicamente no se celebró la audiencia en la primera comparecencia para el segundo cargo.
I believe that's what it was.
Creo que eso es lo que ocurrió.
Ms. Acosta, I know you were here yesterday on the petty theft.
Señora Acosta, sé que estuvo ante nosotros ayer por el hurto menor.
Your bond has been posted on that charge.
Para ese cargo su fianza sí ha sido pagada.
However, there is a no bond hold on a violation of probation.
Sin embargo, hay una petición judicial de detenerla sin fianza por la violación de probatoria.
And that violation is out of Miami-Dade County.
Y esa violación de probatoria es concurriente sale del condado de Miami-Dade.
Okay?
¿Qué debo hacer?
What should I do?
Oh, they will
Nosotros tenemos
notify
que
Miami.
notificar. Va a notificar el condado de Miami-Dade al oficial de probatoria.
Okay?
Okay?
No necesito hacer más nada.
I don't have to do anything else.
Well, not here today.
Bueno, aquí hoy no.
Your bond has already been posted on the first count.
Para el primer cargo su fianza ya ha sido pagada.
Okay?
Okay.
Okay.
All right. Is there anyone else who needs a Spanish interpreter?
No para usted, señor. Está
Judge at
preguntando.
main jail, Christian Alvarado Peña. He's on page 15 and 21 of the court's docket.
It's on 2 pages.
Judge, it appears that he has court tomorrow in both MP division for the counts 2, 3, and 4, the traffic criminal cases, and for the felony in front of Judge Fine.
Señor, me parece que él tiene tribunal, audiencia en el tribunal mañana en la división MP por el segundo, tercer y cuarto cargo y tiene también una audiencia por un delito mayor ante el juez Fine.
Judge, I don't believe probable cause determination is
All right.
necessary at this time.
If everybody's just hold on just a moment,
Si todos pueden
okay?
esperar un momento.
All right. So Alvarado Peña is on 2 pages. I have 1.
Alvarado Peña está en 2 páginas. Tengo uno acá de los casos.
I only have 1 set of paperwork for Alvarado Peña.
Solamente tengo un juego de papeles para.
And I believe that's the case, Your Honor, because I believe only the misdemeanor should have been set for first appearance.
Y creo que ese es el caso porque solamente el caso del delito menor tendría que haber sido fijado para la primera comparecencia.
But it's probably a moot issue anyways,
Pero-
considering the top count.
Quizás sea un asunto mudo.
All right. Just
Nulo.
since Mr. Alvarado Peña is here, I can just let him know
Ya que el señor Alvarado está aquí, le puedo informar
that you have a felony capias, which is a no bond hold,
que tiene una petición judicial de detención sin fianza por delito mayor
and charges 2, 3, and 4 are traffic capiases.
Y los cargos 2, 3 y 4 son orden de arresto de tránsito.
and those have $250 bonds attached to them.
Y esos tienen sumados fianzas de $250 cada uno.
And you have court tomorrow and the following day before your division judges respectfully.
Y respectivamente tiene tribunal mañana y el día después de eso ante sus jueces de división.
All right, good luck, sir.
Suerte, señor.
So anyone else needs a Spanish interpreter?
¿Alguien más requiere servicio de intérprete en español?
All right, thank you.
You're welcome, man. Have a good day.
All right. Juan Lee Orisme on page 18.
Good morning, Judge. How are you?
Good morning, I'm okay.
Okay.
Yes, just okay
Oh.
today.
All right. Hugo Apolanos on behalf of Mr. Risme, Your Honor.
Where's Mr.
Judge,
Orisme?
they're bringing Mr. Arizme into the courtroom now.
Okay.
They're asking if you could go to the next one, Judge.
All right. Erica Lovesmith.
Your Honor, that's North
For
Brown.
hours.
She refused.
She refused.
Yep.
All
Next
right.
one, then let's go. Ford
All right.
and Haley.
I am gonna find probable cause and abstention on Ms. Lovesmith, okay? And then, all right, since Ms. Lovesmith has been before this court several times and, oh, Mr. Shade, you've got two sides of,
Judge, I had Miss Lovesmith too, so there's one down already. And also we did,
Weisbecker?
Weisbecker, so it's really only 8.
Oh, but there's still a lot. All right,
I
let's
don't
see.
disagree with you. I would wait, Judge, we had 9 juries, 9:30.
All right. Thomas Gooden, and then you have Hand, then you have Lininger, and you have Hannigan. You have Duncan and Ross.
Mr. Arizme is present at the main, Judge.
All right. Mr. Shade, you have time for us to do one before
Sure,
you?
of course, of course.
All right. All right, Mr. Arizme is before the court this morning for charge 1, burglary, unoccupied, conveyance unarmed. Number 2 is grand theft. Number 3 is burglary, unoccupied structure unarmed. And number 4 is burglary, unoccupied structure unarmed.
Your Honor, related to, I guess, count 3 and 4, I don't see probable cause for a burglary. I don't see any evidence of there being proof of a crime therein. It looks more like a criminal mischief. Additionally, count 1, it looks like it should be a burglary of a structure, not a conveyance. But I'd agree that there's probably probable cause for count 1 and count 2, but not 3 and 4.
One moment, Your Honor. Your Honor, I would argue, based on the totality of the circumstances, and first of all, they're all structures. I know there's one count of a conveyance. I would agree that 2 of the counts should be attempt. But based on the totality of the circumstances and his statement that he made, I think there is certainly evidence that he intended to commit crime therein. The fact that he's trying to conceal his identity, the fact that he made a spontaneous utterance that he was just trying to make some money, certainly there's no money to be made from just destroying property.
And I would argue, Your Honor, that I'm not sure we can impute that one statement to all 3.
All right, so as to count 1, it was burglary, unoccupied, conveyance unarmed. That is the smashing of the west window of the store and removing bottles of Remy Martin, right?
Yes, ma'am.
And then as to Then at the other probable cause affidavit, unlawfully attempted to enter the Subway store, attempting to smash a glass front door and front glass window with a large brick. It did not shatter, but it did crack. Needed the replacement. So that's an attempted.
And Your Honor, I think you can also infer, considering the one business that he was able to actually smash out the window where he can make entrance is close in time and proximity to the other two, it can be the intent can be inferred to all three.
So there's a Subway store, and then there's Cagney's Liquor that he,
It's ultimately successful.
so then 3 and 4, I'll make a finding for attempted burglary. Okay. I don't think I fully saw the second report, because there are 2 reports. So I'll make a finding for attempted burglary as to 3 and 4, and the other 2 as stated. Okay?
Your Honor, the state is, even though 2 counts are attempts, the state is going to be seeking a $15,000 bond on 1, 3, and 4 pretrial release with a GPS monitor, no return. Your Honor, the state's very concerned, considering that at the time of these 3 incidents, Mr. Arizme was out on a $16,000 bond from just, I believe, sometime in May for burglary of a dwelling and grand theft. And now it's obviously up to the court whether you choose to take any action on that case sua sponte. I can advise you, Your Honor, and I think this is something the court should consider with regards to impact on the community. Pursuant to statute, the victim of the burglary dwelling case provided a sworn statement, and he's advised that the burglary in that case has affected him, has affected his family. He can't sleep at night knowing someone had invaded his home, did substantial damage to his property. It's affected him that he's taking efforts to make sure his kids don't know what happened, because he's worried about how it could affect them if they were to know that someone just went into their home.
Are you moving to revoke bond? Because it sounds like he's moving to revoke bond.
I am not moving to
How much bond did you request?
on each count 15,000. And for the record, I'm not moving to revoke bond. I said it's up to the court whether she chooses to sua sponte. I'm providing the court with information that I think is appropriate for setting bond in this case, and whether she chooses to do so or not, that is obviously up to the judge.
All right.
And I'd ask for a $2,500 bond on each count, Your Honor, for a total of $10,000.
All right, at this time, I'm gonna impose $5,000 on 1. $1,000 is a standard bond on 2. And 5,000 on 3 and 4. Okay? No victim contact and no return to these locations.
Thank you, Your Honor.
Okay?
If Your Honor's not going to take any action on the pending burglary, then I do believe a GPS is appropriate, considering this is now 4 alleged burglaries in a 2-month time span.
He has a pending a case at this time?
That has been filed.
All right, so I'll let a level 2 pretrial.
Thank you, Judge.
Okay? All right, good luck, sir. On page 10, Thomas Gooden. This is a municipal ordinance.
Main jail, Judge.
Judge, these are 3 old cases from 2017 with cases. The city would offer time served.
All right, Mr. Gooden, the city is offering you time served to resolve these 3 municipal ordinance cases. Do you wish to accept that, sir?
Time served?
Yeah.
Yeah, and just so you know, these cases are from all of them, 2018 for no lodge on city-owned property, and then 2018 carrying a concealed carrying a beverage in public, and then number 3 is no lodge on the city-owned property. So adjudication and time served if you wish to resolve those cases.
Yes.
All right, please raise your right hand, sir. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. And Mr. Gooden, do you understand everything that we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
Nope.
Are you under the influence of drugs or alcohol?
What was that again?
Are you under the influence of drugs or alcohol? Do you need any more time to speak with your attorney?
No.
And sir, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Is anyone forcing you to resolve your case?
No.
And sir, have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Gooden?
What?
Guilty or no contest? Guilty or no contest?
No contest. No contest, I
All
guess.
right, I accept your no contest plea.
I don't know. No contest, okay. That's it.
Stick with no contest, Mr. Gooden.
No contest.
There you
All
go.
right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck. All right, William Hand on page 10 as well.
Main Chair.
Good morning, Your Honor.
Good morning, Mr. Hand. You're before the court on 2 misdemeanor cases. They're both municipal ordinance violations. Does the city have an offer for
Judge,
Mr.
it's
Hand?
time served.
Mr. Hand, if you wish to resolve your case today, the city is offering time served. I will sentence you to adjudication and time served.
Will the adjudication be withheld, or I'm just asking?
No, it's not withheld. There'll be a conviction and
Okay.
time served.
Okay, yes, ma'am, I would like to place my plea today.
Okay, please raise your right hand, Mr. Hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And Mr. Hand, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And sir, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I'm aware. I was born in Tampa.
Good. What plea do you wish to enter, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves adjudication and time served on both counts. Good luck.
Thank you, ma'am.
And then Roger Lineger
Judge, this is gonna be easy.
on page 11.
City of Pompano is not giving him an offer
I
today.
figured.
Yeah, this is the MILC.
All right, Mr. Lineger, you're before the court today for two municipal ordinance violations. And the court does find probable cause, sir. And your bond, you have a $25 bond. And I'm gonna leave that in place at this time, okay? Good luck, sir. William Hannigan on page 11.
Yes.
All right, Mr. Hannigan, you're before the court for a misdemeanor capias.
You already know we do this.
This is a capias that was issued June 20th on the charge is trespassing on private property, and the court finds probable cause.
Time served, Judge.
Mr. Hannigan, the city's offering adjudication and time served to resolve your case. Do you wish to accept that today, sir?
The case isn't even mine.
All right, so
Your Honor,
then,
the case isn't even mine.
I heard
don't
you.
know who-
All right, so you've got a $50 bond, so you need to meet with your attorney so you can develop a defense, okay? On page 12, Thomas Duncan.
Right,
Thomas Duncan on page 12.
Judge, the same as Mr. Levy. Pompano does not want to give him the offer.
We should be having a community court up there soon.
Pompano, I think they're trying to.
I hope they do, because we get a lot of traffic from Pompano. All right, Mr. Duncan, you're before the court on municipal, charge 1 is a municipal ordinance violation. 2, 3, and 4 are misdemeanor capuses. And do we know when he goes to court? Can we get a court date for Mr. Duncan? He's got panhandling. It's 3, the misdemeanor capuses are all panhandling, and I guess this new arrest as well. So I'm gonna leave the bonds in place, and Mr. Duncan will be able to see his division judge to be able to resolve these matters, okay? All right, Daniel Roth on page 12.
Sealed offer, time served.
All right, good morning, Mr. Roth. You're before the court on a municipal ordinance violation. The court does find probable cause. Mr. Roth, the city of Pompano is offering you adjudication and time served to resolve your case. Do you wish to accept that, sir?
Yes.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. And Mr. Roth, do you understand everything that has been discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
And sir, do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Okay, what plea do you wish to enter, Mr. Roth? Guilty or no contest?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck, sir.
Thank you.
You are giving them 6 months, right? 6 months. To pay the court costs? Okay. Christopher Dibble on page 12. All right, Mr. Dibble, you're before the court. Charge 1 is resisting without violence. And number 2 is a misdemeanor capious on a municipal ordinance violation for possession of drug paraphernalia. All right. The court does find probable cause. What does Mr. Dibble wish to do?
Judge, the city would offer time served for the MO. He does it for tomorrow.
He does.
And the state would offer time served on count 1.
All right, Mr. Dibble, the offer from the state and the city are adjudication and time served on both charges. Do you wish to accept that, sir?
Yes, ma'am.
All right, are you okay?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Dibble, do you understand everything that you've heard here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol? Do you need any more time to speak with your attorneys? You've got to speak. I see you shaking your head, but you've got to.
No.
Okay. And,
Judge, I would like to ask him one question.
okay,
Thank you, Judge.
all right. And, sir, are you under the influence of drugs or alcohol?
No.
And sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Dibble? Guilty or no contest?
Contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves adjudication and time served on both charges.
Thank you.
Judge, Mr.
Yes.
Dibble has a status conference for tomorrow. Would the
We'll
court please delete that so there's no
yes.
mistaken capias?
We'll delete the status conference for tomorrow. Ronald Bizjack on page 13.
Your Honor.
Okay. All right, Mr. Bizjack, you're before the court on a misdemeanor capias. It's an alcoholic consumption violation.
Correct.
What do you want to do today, sir?
Resolve it.
All right. I'll sentence you to withhold adjudication and court costs if you wish to resolve it. Do you wish to accept that?
Yes, ma'am.
Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. And Mr. Bizjack, do you understand everything we've discussed here today?
Yes, ma'am, I do.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And sir, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right.
Correct.
And have you ever been treated for mental or emotional illness?
Never.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, I am, but I don't have to worry about that. I was born in North Broward.
All right, I am required to ask everyone that, so, just so you understand.
I understand.
All right, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is a withhold adjudication and court costs. Good luck, sir.
Thank you. You have a wonderful day.
You too, sir. Thank you. All right. All right, on page 19, we have someone signed in the courtroom for Leskiel Richards. Is he in the room yet, Mr. Miller?
Bringing him in now, Judge.
All right, when he's in, you let us know. Thank you.
Yes, ma'am.
All right, Haley Ford.
Your Honor, that's North Broward again. She also refused.
All right, Ms. Ford has refused. This is a misdemeanor capias. So find probable cause. She'll go before her division judge. Okay? Ashley Breedlove,
Judge,
yes? Yes. Yes, Mr.
Your Honor.
Miller. Yes.
Page 12, Ryan Hash has a municipal ordinance and a state misdemeanor charge.
What's the last name?
Ryan Hash, page 12.
I guess Mr. Shape missed that one, I guess.
As to count one, Judge, he advised me that he is interested in resolving. Mr. Hash?
All right, on page, page is he on, 12? Ryan Hash?
Yeah, it does appear the municipal ordinance would get subsumed by the state charge.
Oh. Oh, maybe that's why he didn't call it. All right, so Mr. Hash is before the court on a trespassing matter, and then the municipal ordinance is street solicitation. All right.
Go for it.
So he wants to resolve the case today, Mr. Miller, is that what you said?
Judge, he indicated to me that he will resolve both cases and he will waive an attorney for count two.
The offer on count one would be an adjudication, time served, no return.
Now I'll dismiss the municipal ordinance violation. All right, so if Mr. Hash wishes to resolve the case, will be adjudication time served on the trespassing, and then I'll dismiss the MO charge.
Yes, Judge.
All right.
Yes, Judge.
All right, Mr. Hash, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Hash, do you understand everything that has been discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And do you need any more time to speak with your attorney?
No.
You understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence as to the trespassing charge, adjudication, time served. Good luck, sir.
Go that way.
All right, Ashley Breedlove.
Your Honor, she's North Broward. She's a medical reset.
All right, Miss Breedlove is a medical reset.
Ms. Perez, you're going to be next.
Jeanette Perez.
North Broward, Your Honor.
Good morning. Ms. Perez, you're before the court. Charge one is larceny of a credit card. Number two is illegal use of a credit card more than 2 times in 6 months. And number three is illegal use of a credit card. Number four, illegal use of a credit card. Number five, petty theft. Number six, petty theft. Number seven, petty theft. And the court finds probable cause as to all those charges.
Your Honor, Ms. Perez has asked me to request that the court leaves the bonds in place.
Okay. 1, 2, 3. All right, the court finds probable cause and the bonds, the standard bonds will remain. Okay.
Your Honor, before we move on to the next case.
Yes,
Do we have to reset Ashley Breedlove? It's on a warrant for a violation of pretrial.
I didn't even look at it. She just,
Yeah, and she's up for a status tomorrow in division.
all right, yeah, we won't, all right, Ms. Perez, good luck. On Breedlove, we will not reset. Charge one is a violation of pretrial warrant with a no bond hold. It's not for magistrate anyway. And number two is also a no bond hold on a violation of probation, so
They're actually the same case.
it's the same. So
Yeah.
she'll go before her division judge tomorrow.
Thank you,
So,
Judge.
okay, thank you. And Brittany Adams,
Your Honor, they called me this morning and told me to remove her from the docket.
she was deleted. Okay, thank you. Brittany Adams. All right.
Your Honor,
Yes, Mr. Miller.
who was the defendant that you requested for private counsel? What was his name?
Is that Richards?
You mean one that we handled earlier?
No, the one that we were bringing up when you asked.
Oh.
Yeah, it's Mr. Richards.
It's Richards, less skill Richards, and it's family members, I believe, are here. So,
President.
so,
Please give me some space, thank you.
so have you spoken to him already?
I haven't had an opportunity, we were just in the process of signing up the public defender, I
Oh,
believe.
then please do that, because it's not private counsel that signed in, it's family members.
It's not.
No,
Very well, I'll speak with him, thanks, Judge.
okay. All right, Sherry Nicholas,
North Broward, Your Honor.
Good morning.
good morning, Ms. Nicholas, you're before the court for possession of fentanyl, and the court finds probable cause. And does Ms. Nicholas have priors?
Dated priors, Judge.
All right. Ms. Nicholas, I am going to release you to pretrial supervision, ma'am.
Okay,
All right, you must report to the pretrial office no later than tomorrow morning. If you don't report, a warrant will be issued for your arrest. Do you understand that?
yes, ma'am. I was
Also, let me finish. Also, you'll be subjected to random drug testing, so that's going to be part of your pretrial release. Do you understand that?
Yes, that's what I wanted to talk to you about, Your Honor.
Well,
I'm homeless. I'm homeless at this time, and it's hard for me to get around.
well, well, this is a, let me, Ms. Nicholas, just so you understand, this is a third-degree felony charge. You are facing the maximum sentence on a third-degree felony is 5 years in prison. So there is $1,000 bond, which I am not letting you post the bond. I'm releasing you to pre-trial. Most of that is to make a phone call to the office, but you have to go to the first time for signing up. So,
Okay.
so you know, so it's either
I
that,
agree.
okay?
I agree to do that. Thank you, Your Honor.
All right, good luck.
Thank you. God bless you.
Okay.
If she asks the deputies, they may be able to help her out a little bit.
Oh, you mean to get to the, okay, all right. Cheyenne Daly? Oh, Paul, right. All right, Ms. Daly, you're before the court this morning. Charge one is a felony violation of probation. It's a no bond hold. And number two is a misdemeanor capias.
Your Honor,
Yes.
she can be ROR'd on count one. The officer doesn't note any basis for a violation. I can tell you, the theft can't be a basis for a violation because she already had a VOP, a 94806 VOP. Right, as you see, this is a petty theft, this is a capias. When she was first arrested,
Right.
she was held on a 94806 on the VOP that she resolved, so obviously the offense can't be a basis for a second time, so.
That's
Okay.
exactly what Miss Daly and I were talking about before court.
All right, so ROR Ms. Bailey on the violation of probation matter. And then the misdemeanor capias is on a petty theft. There's a $250 bond.
I don't know that she's gonna be able to make that.
Well, she didn't show up for arraignment on June 25th.
If she had moved, Judge, and they sent the notice to a different address.
Where does she live?
What is your address, Miss Daly?
The new one is 5254 Northwest 16th Street, Lauderhill, Florida. My probation has a new address. That's why I don't know why it keeps sending mail. They're using the address that's on my license.
Well,
Well, you know you gotta change your license to your correct address.
Even if my probation officer comes and do my visits and she been there, she knows.
that doesn't matter. You need to, if you move, if you change your address, there is a specified amount of time that you have to change the address on your driver's license. So that has to be changed.
And I don't know if.
And that's
Ms.
against the law if the time passes and you don't change the address on your driver's license.
Your Honor, I don't know if Ms. Daly would be interested. There is a documented offer from the state, if she's interested in resolving.
All right, what is the offer?
The offer is adjudication, time served, no return to the Walmart involved in this matter on Atlantic Boulevard.
All right, Ms. Daly, I'm not telling you what to do, but there is an offer from the state as in regards to the petty theft charge, which is the offer is adjudication and time served, no return to Walmart on Atlantic Boulevard. Do you wish to accept that?
So time served meaning now.
Time served meaning this case will be over today if you take that plea.
Okay.
All right, please raise your right hand. You swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. I guess I need to ask, are there any prior petty thefts?
There's the grand theft that she's on probation for. I don't know if there's anything in addition.
Okay, so she's already, all right. Ma'am, do you understand everything that has been discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
And ma'am, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, ma'am, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, guilty or no contest? Guilty means you're admitting that you've done it. No contest is saying I'm not admitting or denying, but I wish to resolve this. I believe this is in my best interest.
No content.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, time served, and no return to the Walmart on Atlantic Boulevard.
And Your Honor, I would just request that the court order the clerk to delete the
Right.
violation
and-
of probation
And
hearing.
if the clerk would delete the two hearings that are set.
And I apologize.
Delete.
And I apologize if Mr. Reedy already advised Ms. Daly this, but it's probably in her best interest upon her release to reach out to her probation officer to advise what's going on.
Okay, yes. No. Right, just the misdemeanor. The, right. No, also the felony, because,
The court found there's no basis for a violation of probation.
let me write that in. No PC for that one, okay? Yes, thank you. All right, good luck, ma'am.
Thank you.
All right, Carmen Aviles. All right. Ms. Aviles, you're before the court. Charge 1 is grand theft. Number 2 is fraud, uttering a false instrument. Number 3, unlawful possession of personal ID of another. And number 4 is defrauding a financial institution. The court does find probable cause. And I'll hear from the parties as to bonds.
Yeah, you can go ahead if you got any requests.
Judge, Ms. Aviles, 15-year resident of South Florida. She lives here with her mother, who she takes care of as a caregiver. She is disabled. She cannot afford to post any bond. We are requesting pretrial release.
Does Ms. Aviles have any prior criminal history?
I'm being advised there was a warrant issued in May out of Dade on a petty theft. We're pre-trial's checking to see if there's anything else.
Judge, just to further advise the court, Ms. Aviles' mother is 84 years old and confined to a wheelchair. She's, Ms. Aviles is the only caregiver.
It looks like Ms. Aviles has several warrants. There's a warrant from Dade and a warrant from where else?
Hendersonville, North Carolina.
North Carolina. Okay, so there's, and do we know how recent those warrants were?
Dade County warrant was just issued May of this year.
She's advising those warrants are 15 to 20 years old.
Yeah,
No.
I'll just, I
Hold
don't
on.
think, yeah, Dale might not be able to, Dale, we're being advised the warrant out of Dade is from May of this year, and we're getting the information now about the warrant out of Carolina.
North Carolina was just issued in '09.
And the warrant from North Carolina was issued about 10 years ago.
Okay. All right, I'll release Ms. Aviles to pretrial supervision, but it'll be on a level 2 pretrial.
Thanks, Judge. We just cleared that up.
What did we clear up? Level 2
Just-
pretrial is what I'm gonna put her on.
Level 2. Thank you,
Yes.
Judge.
Who's next? We got resets next.
We're ready to go with Mr. Richards.
Okay,
Come on.
all right, so let's address Leskie Richards on page 19.
So just because it's been a while, Judge, another judge signed a warrant on the counts 2 and 3. So a probable cause determination has already been made. Is that correct?
That is correct.
Thank you, Judge. But I do believe he's entitled to a bond on those charges.
All right, Mr. Richards, you're before the court. Charge 1 is operating without a valid driver's license. Number 2 is a traffic infraction that's not for magistrate. Number 3 is robbery, no firearm or weapon. And number 4, aggravated battery causing bodily harm. And number 5 is a traffic capias. Okay? And the court finds probable cause, and I'll hear from the parties in regards to bond.
Your Honor, I just need one moment, please.
Judge, as to count 5, Mr. Richards advised that he actually had court yesterday
Okay?
and that he was arrested at 10:48 p.m. and not brought to court. And so we'd ask the court to set that, if that bears out, we'd ask the court to set aside that no bond and set a bond in that.
He had
case.
court yesterday on the, well, yeah, I didn't, okay. It does say 500 on the capias. All right, good morning, folks. Is there something that you wish to say to the court?
Yes, Judge, this is Mr. Richards' sister and girlfriend.
Ma'am, I'm gonna ask you to remove the gum. Okay. Is there something you wish to say?
We're just looking for him to get a bond so that he could be able to come out, because the charge from yesterday with he did have court, but we rescheduled it, so they're supposed to be sending something in the mail. And then, the other charges that he has, we're just looking for him to get a bond so he could be able to come home.
Okay,
Your Honor, I'm going to be requesting a $25,000 bond on count 3. I have no objection to an ROR on count 4, pretrial release of the GPS monitor, no victim contact, no witness contact. The reason for this, in full candor, Your Honor, you may recall, you had one of his co-defendants previously in April of this year, Markeith Yarbo. You might remember the facts. The allegations were a group of co-defendants attacked the victim after there was a verbal argument at a laundromat. The victim was attacked by the group of individuals and robbed. There was a female with the victim. She was attacked as well. In that matter, you set a $25,000 bond on the strong arm robbery and the aggravated battery on Mr. Yarbo. The aggravated battery was merged into the strong arm robbery. I have no reason to believe that won't be the same situation for Mr. Richards. So that's why I'm asking for the $25,000 bond instead of the total bond of $50,000.
and is there prior criminal history?
Additionally, Mr. Richards is out on bond right now for carrying concealed firearm and unlawful use of false name identity from last year.
Mr. Linder, could you spell the last name of the co-defendant?
Yarboughh. It's also in the arrest warrant affidavit, you know.
Thank you.
Mhm.
He went to arraignment yesterday on 5? So, all right, so we,
The warrant on count 5 was withdrawn yesterday, if I'm reading
Yeah.
this correctly.
I don't know if he was there or not, it was just, but he does mention in Odyssey that the capias was withdrawn by Judge Davis.
all right. So we'll ROR that one. And, how much bond is he out on the other case?
Essentially $1,000, Your Honor, technically $999.
All right, finding probable cause as to count 3, I am going to impose a $25,000 bond. Count-
Judge-
Yes.
Would you consider something less than that?
Judge, I would move for
No,
reconsideration.
because the
I
the
know,
other
but-
option is that I revoke his bond that he's out on, so.
We'll take it, all right.
$5,000
All right.
bond. And, level one GPS. Okay,
All right, well, that's,
Judge, would the court consider level 2? He does have a job. He works as an arborist. He attends school at Florida Barber College as well as Florida Career College studying HVAC. He is a lifetime resident. He does have strong family ties.
when was the
as
last
demonstrated.
time he went to class? When?
Monday.
2 days ago, Judge.
And how long is he, what time does he go to school?
9 to 4.
9 to 4, Judge.
Monday through Friday? And, you work where?
I'm an arborist.
He cuts trees, Judge. He's an arborist.
I understand that's what an arborist is, but
What's the name
where
of the
does he
company?
work?
West Park area. West Park area.
That's the name of the company?
No, that's the name of an area.
Yeah.
That's why.
Is he self-employed? What is?
Oh, no.
One moment, Judge. She's saying, he's advising me he works for a private individual who cuts trees.
All right, I'll put him on the level 2, okay?
Thank you, Judge.
All right.
And Your Honor, just also,
No victim contact, no contact with the other co-defendants, okay?
and Your Honor, you ordered his other co-defendant not to have any contact with any of the listed witnesses in the affidavit.
With the who?
Witnesses.
All right.
I'm just trying to keep them all the
No
same.
victim
that's all.
contact, no contact with any witness involved in the case, and no contact with the defendants, okay?
Thank you, Judge.
All right,
Thank you,
yes,
Judge.
ma'am,
So the co-defendant meaning like the other person who got arrested in April?
right. Whoever was there were other persons that were involved in this incident, those
Right.
other persons, he's to have no contact with them. Okay, Olivia Montgomery,
Looks like she's on loan,
count
Judge.
4 is ROR. Okay. And Ms. Montgomery is on medical loan. And Alexis Kubisky, do we have her today?
North Broward, Judge.
I'm advised she refused.
Ms. Kubisky refused. It looks like we had 2 medical resets before, so. We'll
Your
see.
Honor, she was actually moved to the Paul Ryan facility.
Oh, okay. But she still refused, right?
Yeah, we called them up over there this morning, so I don't know if she refused. I'm not over there, but we made them aware that she was over there.
All right.
Yeah, I spoke with Paul Ryan, and that's what they told me, Judge.
Okay, thank you. All right, Annette Ward.
Miss Ward is a medical loan.
She appears to be on loan as well, Judge.
Mr. Ward is on medical loan. Janitha Wright.
Ms. Spray is present at the main jail, Judge.
All right, Ms. Wright, you're before the court. Charge 1 is aggravated battery with a deadly weapon. It's domestic. And the court finds probable cause.
Where does it say? Oh, they changed.
Looks like this was an incident from May of this year, and so there was a warrant. Does Ms. Wright have any priors?
One moment, Your Honor. I know, I just. Is it still open? Theft, yeah, I got it. Yeah, but it was. Your Honor, I'm showing a prior theft and resisting without violence out of Dade County in 2018. Your Honor, based on the allegations, I'm requesting a $3,500 bond and no victim contact.
Judge, Ms. Wright is a lifetime resident of South Florida. All of her family does reside here. She does work. She works at a car wash. She has a place to live when she gets out. Asking the court to set the bond at $1,000. She indicated that she can afford a $1,000 bond.
Yeah, who's this?
All right, I'll set a bond at $1,000, no victim contact until further order of the court.
Thank you, Judge.
Siobhan Zambrano.
Present at the main jail, Judge.
Just hang on one second.
All right, Mr. Zambrano, these are change of charges, the capias for change of charge. So now you're facing false imprisonment, and number 2 is battery, second or subsequent offense. How much bond did he have before? Because it
Your Honor,
looks like,
Yeah,
yes.
the bonds were set at 50,000 on 1, 25,000 on 4. Pre-trial release of the GPS monitor level 2. Your Honor, I believe he's, let me see, he's just checking to see when his arraignment is.
Does he still have that Palm Beach County hold?
Confinement would be able to advise the court of that. And he's scheduled for arraignment tomorrow because of that, before Judge Allspector. Because of that, Your Honor, I'd ask that the court keep the bonds in place and any modification can be heard by Judge Allspector. And if the victim wishes.
Are they lateral changes? What was,
I believe, yes. Your Honor, false imprisonment is a third, I believe. So that's still a third-degree felony.
okay,
Aggravated assault is a third, so everything's still a third-degree felony.
okay. All right, and when does he have court?
Tomorrow morning at 9 a.m.
All
before Judge
right,
Allspector.
so 50,000 was the bond on count 1 and 25 on 2?
Yes, ma'am, with the
With
GPS level 2.
level 2 GPS?
Yes, ma'am.
All right, so Mr. Zambrano, I'm going to leave all those in place, and it is my understanding that you'll see your division judge tomorrow, okay?
No, it's been transferred out because I wonder if I was
All right.
it's dating violence.
Desang May,
So just send it through the regular. Whoever's supposed to have the paperwork already has the paperwork, the file. No, I'm saying the file.
Mr.
This is
May?
not in custody.
He is present at the main jail, indicated he would like to resolve this charge if possible.
all right, Mr. May was before the court yesterday, I guess he was being released. And they found the scapeus?
Likely, yes.
All right, so is there an offer for Mr. May?
One moment, Judge.
Mr. May, just for information, this capias is for trespassing, and this was a capias that was issued October 9th of 2018. Okay,
Bless you. And, Your Honor, the offer from the state would be an adjudication court cost, excuse me, no return to 2851 Sterling Road in Dania Beach. Nothing else.
All right. Mr. May, do you wish to accept that offer?
He said yes, Your Honor.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Sir, do you understand everything that has been discussed here today?
Yes.
Is anyone forcing you to resolve your case?
Domestic. Oh.
No.
Are you under the influence of drugs or
You are the
alcohol?
domestics.
No.
Do you need any more time to speak with your attorney?
No.
And sir, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes. Yes.
What plea do you wish to enter, sir? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentencer's adjudication, time served, and you are not allowed to return to 2851 Sterling Road. Do you understand that, sir?
Yes.
All right, good luck.
Thank you.
All right. Let's take a brief recess.
Roger that.
All right, we're back on the record. Tracy Smith. Tracy Smith at North Broward.
Yes, Your Honor.
Kind of.
Good morning, ma'am.
Good morning, Mr. Smith. You're before the court on a petty theft charge, and
Yes, ma'am.
also you have a violation of probation. It's with a no bond hold, and you have court tomorrow before your division judge. And the court finds probable cause. The bond on count 1 is $750. Okay.
Yes, ma'am.
All right. Good luck.
Good luck, Tracy.
Yes.
Your Honor,
Yes.
I have one more, Mr. Miles James on page 24.
And Your Honor, I'm going to be asking that matter be reset for the PM. Detective Carlo Fargnoli of the Fort Lauderdale Police Department is going to be coming in to testify.
All right. So we're gonna reset Mr. James as soon as I can. Oh, the last name is Miles? We have it? All right, so James Miles will reset for the PM.
Okay, thank you, Your Honor.
All right. All right, so Quasi Simpson.
Here, take a look.
Present at the main judge. Judge, Mr. Simpson advising he would like to resolve this case if possible.
All right, Mr. Simpson, you have a trespassing charge before the court. I do find probable cause. State, do you have an offer for Mr. Simpson?
Yes, Judge, it would be time served, no return.
All right, Mr. Simpson, do you wish to accept that offer? The adjudication and time served, no return. Okay, please raise your right hand, sir. Swear or affirm to tell the truth?
Yes.
You can put your hand down. And Mr. Simpson, you understand everything that has been said to you today?
Yeah.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand, sir, you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yeah.
And sir, have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Simpson? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, time served, and no return to that location.
Thank you, Judge.
Good luck, sir. Glenroy Hoggart.
Present, the main judge indicated he would like to resolve this if possible.
All right, sir, you are before the court for a petty theft charge. The court does find probable cause. Does the state have an
theft.
offer?
One moment, Your Honor. Was it dropped? Keep going. Keep going. Keep going. Just checking to see if there's prior thefts, Your Honor.
Okay.
Keep going. Just keep going looking for thefts. Keep going. That's on the theft offense. He's also 15 at the times. Offered to be a withhold court cost, Judge.
Okay. All right, sir, you'll be sentenced to withhold adjudication and court costs if you wish to resolve the case. Do you wish to accept that?
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And, how do you say your last name?
Hoggy.
Hoggett. So, do you understand everything, that has been said to you today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter? Guilty or no contest?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence is withhold adjudication and court costs. Good luck, sir. Kenzo Milos.
Off you go. Judge, Mr. Mellis is not going to be in court with us this morning. However, I believe we have a probable cause argument to make.
Yes, that is correct, Judge.
I beg your pardon.
Yes, no?
We do have a
Yes, he's coming.
Oh, he's coming?
Stand here, please.
All right. Are you making the argument?
Yes, I'll make the argument, Judge.
Okay.
It applies us to count one, the disorderly conduct pursuant to Florida statute 87703 for breach of the peace. It states whoever commits such acts as are of a nature to corrupt the public morals, or outrage the sense of public decency or affect the peace and quiet of persons who may witness them.
I have no objection, Your Honor.
Judge, I would like to further Mr. Reedy's argument.
I'm not gonna find PC for count one, so.
I would argue there is no PC for resisting. This was a citizen contact that he chose to break off. So there was no lawful order for him to obey.
No, then,
And the first line of the PC, it was initiated as a citizen contact. And since no crime was committed, there's no investigation. There's nothing for them to detain him on. He's entitled to break off a citizen contact at any time.
That's fine, Your Honor. I have no objection, and I'm not going to be requesting any time to perfect.
yeah, when they, start off the line. All right, no probable cause for count one and two. LRORM.
Thank you, Judge.
Austin Davis.
Present at the main, Judge.
All right, Mr. Davis is before the court. Charge one is DUI, alcohol or drugs. Number two is DUI with damage to property or person of another. Number three is DUI with damage to property or person of another. Four is DUI with a breath level greater than .15. And number five is not for magistrate, is a traffic infraction. And the court finds probable cause.
Judge, Mr. Davis is in a kind of a situation here. He's from Kentucky. He's down on vacation. He can't get anyone to post his bond. He has signed up for the public defender's office, and I've explained to him that once he is released, if he is released, that we can file paperwork to keep him from having to come back and forth from Kentucky, but then ultimately he'll have to come down and address these issues. He does understand the ramifications of failing to appear in court when called. specifically that he would be transported from Kentucky at his own expense in a most uncomfortable situation. I don't know what his prior record is like, Judge. I know he's going to be down here for another 2 weeks before he returns. He works as a certified nursing assistant there. And so we would ask the court, under these circumstances, if you would release him to pretrial, allow him to return to his home state, and we'll take care of making sure that all of the documents are filed.
Do we have any record or any information on
Your
Mr.
Honor,
Davis?
I really have no information on him. Frankly, Your Honor, considering this is a DUI, he has no ties to the community. Pretrial really serves no purpose on an out-of-state resident, Your Honor. He could be calling in from anywhere. I would ask, I'm not necessarily asking that the bond be kept at $3,500, but I do believe a bond is appropriate, considering this involved a crash with two other vehicles with an enhanced breath.
Judge, Mr. Davis is advising me this is a first offense for him anywhere. So, I mean, the main thing is if he, whether we can get him back to court. And again, if they do file and he doesn't return, it's a felony, they extradite from Kentucky. So I would just ask the court, rather than keep him in custody for an indeterminate period, because he cannot afford a bond and he can't find anybody to post the bond, that we take a chance with this one and release him on his own recognizance.
Well,
He promises to return to court, Judge.
he has no ties to the community. There are two other vehicles that were damaged in this crash. I'm gonna leave the bonds in place, but I will, ROR him on 2 and 3 and then leave the other bonds in place. So he has a total of $1,500 bond.
Thank you, Your Honor.
Okay. Devin Brown.
Mr. Brown is proceeding pro se this morning, Your Honor.
Mr. Brown, you are before the court this morning for driving while license suspended, second offense. And then number 2 is a traffic infraction, which is not from magistrate. The court does find probable cause, sir. And your bond is $100. Good luck, sir.
All right.
Luciano Santos.
Your Honor, he's going to be a medical reset.
Mr. Santos is a medical reset, thank you. Sean Inman.
Sean Inman? Yes.
All right, Mr. Inman, you have a traffic KPS, and you also have a civil writ, and the court finds probable cause.
Your Honor.
Yes.
Mr. Inman has advised that he would like to resolve count 1. He was not aware that that he had a court date. He reporting that he recently had a stroke and he's on medications. He's waiting on his SSI. He does live with his sister to take care of him. The court will allow either to ROR him on the KPS. That would allow him to address the civil purge amount of $261.
It's an unlawful tag sticker is the Capias.
I mean, would he like to know what the offer is?
Yes.
The offer's a withholding court costs.
So, one moment, Judge.
Yes.
Yeah. But were they work with? Okay. I don't care about that. I don't care about that. Yeah, I don't care about that. Okay. Please.
Yes, Judge, you'll accept that offer.
All right, Mr. Inman, please raise your right hand.
Yes.
You swear or affirm to tell the truth?
Yes.
You can put your hand down, sir. And sir, do you understand everything that has been discussed today?
Yes.
Do you need any more time to speak with your attorney?
No.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And sir, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
She's saying you can go to trial. If you plead today, you're not going to trial.
Okay. That's
All right.
what I want.
Okay. And have you ever been treated for mental or emotional illness?
No, I'm not.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Okay.
Do you understand
Yes.
that? What
Yes,
plea
ma'am.
do you wish to enter? Guilty or no contest?
No contact.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is withhold adjudication and court costs. Good luck, sir.
Thank you, Judge.
Okay, Senator.
Jorge
You're done with that, now you just have to
Martinez.
pay the-
All right.
Oh, Paul Ryan.
All right, Mr. Martinez, you're before the court today. It's an ad charge.
Yes.
Lewd and lascivious act, victim 12 years of age.
Yeah,
or
Your Honor,
under.
this is just an additional charge against one of the same victims. You may recall the allegations. This involved the first case allegations that he supplied a minor with drugs. The minor slipped into a coma. Then there was a second allegation with a second minor and providing that minor with marijuana. He's being held no bond on the other case. You would set the first count on this case at $75,000, pretrial with the GPS monitor level 1. The state would be requesting that Your Honor set the same bond.
Okay.
Your Honor, Mr. Martinez has private counsel on his other cases. I'm sure that they probably want to know about this too.
Yeah, but I don't have my lawyer's phone numbers on me. They're upstairs.
Okay.
I can get that, Your Honor.
Hold on just a moment, Mr. Martinez.
Okay.
Has he been to court on this charge?
Yes, he
This
was.
ad charge
I'm showing he was actually arraigned on Monday.
on this count?
Yes, on this entire case, yes, Your Honor.
Okay.
His attorney filed, who's Jonathan Marn, filed a written plea of not guilty for the arraignment. I can provide you with the.
Yes, please.
1177.
Okay.
Jonathan Martin's office, may I help you?
Good morning. This is Judge Jackie Powell. I'm calling from open court. Is Mr. Martin in the office?
He's not in the office. I can give you his cell phone number.
Okay.
Just wait, don't grab me yet. I gotta.
954.
Hold on just a moment. Go ahead, 954. Mm-hmm. Okay. All right, thank you. All right.
Hello, Jonathan here.
Good morning, Mr. Martin. This is Judge Jackie Powell. I'm calling you from First Appearance Court.
Yes.
I just wanted to let you know, Jorge Martinez is before the court today for an ad charge on number 8. I think maybe he has already been to court and been arraigned on it, but I wasn't sure that you were aware that he hasn't, I guess he hadn't come through a first appearance on this charge as yet, so that had to happen, even though he's already been arraigned.
Well, actually, I think technically, if he, with respect to the court, if he's been arraigned and they add a charge, it doesn't have to go through first appearance court. It usually goes through the trial division of his regular judge.
No,
But apparently they want to
unfortunately,
put this guy in
no.
front of the cameras as much as possible.
No, I
I
don't.
appreciate the courtesy call. Can you reset it for tomorrow morning or this afternoon?
Well, I can reset it, but I can also tell you that this has nothing to do with bringing him back into court. This is how it happens every day.
Okay.
Okay? So if you want me to reset it for the afternoon, I can. Do you want to, this afternoon or tomorrow? Which one do you prefer?
Tomorrow morning would be great.
All right, well, we start at 8:30, so
I'll be there at 8:20.
All right, good luck. See you tomorrow.
Thank you. Have a good day. Thank you very much for the courtesy of the phone call.
Okay, bye.
Bye.
All right, Mr. Martinez will be reset for tomorrow morning so his attorney can be here. Okay? All right. Chisnell Florimon.
Present at the main jail.
All right, Mr. Florimon, you're before the court so that I can advise you that there's an immigration hold. It is a no bond hold and you should be going before a immigration judge, okay? Good luck.
Thank you, Judge.
Christian Page.
And, Your Honor, if I may approach,
Yes.
this is actually for the next, Mr. Page in the next case also.
Okay. Oh, I see. This. All right, Christian Page,
Yes, Your Honor.
where is he at?
He's in, Conti.
All right, Mr. Page, you're before the court. Charge 1 is possession with intent to sell, manufacture, or deliver cannabis. Number 2, no, these are ad charges. So number 4 is possession with intent to sell, manufacture, or deliver cannabis. Number 5 is possession with intent to sell, manufacture, or deliver hallucinogen. Number 8 is possession with intent to sell or manufacture or deliver THC. Number 7 is possession cannabis over 20 grams. And number 9 is trafficking in synthetic cannabinoid, 1,000 grams or less than 30 kilos.
And Your Honor, before the court makes a finding.
Yes.
The court should find no PC for count 5. I spoke with Detective Perez.
Count 5.
The hallucinogens.
Okay.
I spoke with Detective Perez, who authored the probable cause affidavit. He advised me they didn't have the testing equipment at the scene to test the hallucinogen, the mushrooms, so that should be no PC.
So no probable cause as to count 5.
Yes, and just for the record, Your Honor, because I note the original probable cause affidavit made no mention of any of the drugs being tested. I provided the court and Mr. Reedy with a supplemental report, and noting, because it doesn't have any names on it, that the offense report number matches the offense report number on the probable cause affidavit, so the court can have confidence that this is a part of this case.
Okay.
Noting that the cannabinoids, THC and cannabis were field tested.
All right. All right, so the court finds probable cause for 4, 6, 7, and 8.
And Your Honor, the state's going to request that you keep the bonds in place. Mr. Page is being held no bond on count 1 for home invasion robbery with a firearm.
All right, and so the standard bonds will remain in place. Good luck, sir.
Thank you, Your Honor.
And then we have Emmanuel Hernandez.
Women's facility.
All right, Mr. Hernandez, you're before the court for additional charges. Number 3, possession with intent to sell, manufacture, or deliver cannabis. Number 4 is possession with intent to sell, manufacture, or deliver hallucinogen. Number 5, possession with intent to sell, manufacture, or deliver THC. Number 6, possession of cannabis over 20 grams. And number 7, trafficking in synthetic cannabinoid. The same as your co-defendant. I'll find no probable cause for, in this case, it's number 4. Okay?
And Your Honor, the state provided the same supplemental report for Mr. Hernandez as Mr. Page. Assuming the court finds probable cause, he's also being held no bond on a home invasion, robbery, firearm. So the state would be making the same request as far as bond amounts.
All right, so the court finds probable cause as to 3, 5, 6, and 7. And the standard bonds will remain in place, okay? Eric Hillebrand, Hillebrand.
He's in regular court this morning, Judge.
Mr. Hillebrand is in court. We'll have to reset. Joseph Morgantill.
Morganti is present at the main jail, Judge. His private attorney is Robert Trakeman.
Mr. Morganti, do you know Mr. Trackman's number?
Oh, no, I don't. I wasn't prepared to get taken into custody when I went into court yesterday.
They say Robert Trackman represents him?
Oh, you know what? That's what he said, but this one, he was taken into custody yesterday by Judge Casey. So these are all court orders with no bond hold. Your attorney was in court with you yesterday?
Yeah, it was.
And I can tell you, see, Your Honor, frankly, and I don't know if you have there's an additional 94806 on a VOP, but that and the court order, no bonds, there's really nothing for the court to do. The new charges are not in custody. The capias were served on the case, and Judge Casey ordered a hearing to set new dates for Friday. So obviously it's been considered by Judge Casey.
All right.
What is my case with Casey? They never gave me my paper for my check.
Well, apparently you're going to go back to court on Friday. Judge Casey took you into custody yesterday, so those are not for magistrate. Those are all no bond holds. As to the possession of heroin and the possession of drug paraphernalia, what's this?
That's a lie.
All right, well, you will discuss that with your attorney, okay?
Yeah.
All right, so the court.
Brought in.
All right.
I never got arrested.
Mr. Morganti, don't talk about your case. The court finds probable cause, and you have a bond.
Them charges?
Oh, what was that?
Those charges were filed?
No,
That's
these are
arrest?
these are new arrests. These are new charges.
And the possession, sir, the possession of heroin and drug paraphernalia, sir, has been filed. It's a not in custody capias.
Okay. All right. Good luck, Mr. Morganti. You'll see your attorney.
All right, thank you.
Your attorney, you got an attorney, talk to him.
I'm sorry? Mr. Prophet, Diedrich, what about, what now? What about it?
Main jail, Judge. He's approaching.
Just let it go.
I know what he was asking.
No, just let it go.
All right, Mr. Prophet, you're before the court for charge 1, driving while license suspended. Number 2 is grand theft auto. Number 3 is possession of MDMA. And Mr. Prophet, I find probable cause as to those charges. Does anyone wish to be heard as to bond?
Yeah.
Yes, Judge. Mr. Prophet is a lifetime resident of South Florida. His entire family lives here, so he has strong ties to this community. He currently lives with his grandmother. He says he's never missed a court date, never had a violation of pretrial. We're asking the court to consider pretrial in this case.
One moment, Judge.
Thank you.
I don't have an objection to pretrial, Judge.
Right, so Mr. Prophet, I am going to release you to pretrial supervision. Sir, you must report within 24 hours of your release. If you don't report, a warrant will be issued for your arrest. Sir, I'm also going to add that you'll be randomly tested for drugs during the time on pretrial, okay?
Thank you, Judge.
Okay.
You have to show up here tomorrow. Okay? Go to this place tomorrow. Right across the street. Here's the courthouse. Too bad. I got you out. Don't forget to come back.
All right, Sheldon Mason.
Mason, he's present and approaching, Judge. I advise Mr. Mason he has court date in front of Judge Weeks tomorrow at 8:30.
Okay. All right, Mr. Mason, you are before the court. What's this?
Gotta save it.
The charges that are presented, 1, 2, and 3, burglary, unoccupied conveyance unarmed, 4, 5, and 6, felony violation of probation, those are no bond holds. Number 7, burglary, unoccupied conveyance unarmed. Number 8, probation violation. Number 9, probation violation. Number 10, false owner info for pawn items. Number 11, burglary, occupied dwelling unarmed. Number 12, dealing in stolen property. 13 and 14, violation of felony probation.
Your Honor, I'm sorry, wait.
Yep.
Did Your Honor find probable cause, or am I jumping the gun a little?
I'm just making sure there was one this morning that it was not burglary, but it's not this one. All right, the court does find probable cause.
Your Honor, considering the totality of the circumstances, the numerous offenses, and that he's on probation for burglary where there was already a warrant for his arrest before these new offenses, I'm requesting a $3,500 bond on the burglary conveyances. That'd be 1, 2, 3, 7. On the burglary of the occupied dwelling, I'd be requesting a $15,000 bond. And obviously, no victim contact, no return.
All right. All right, Mr. Mason, as your attorney told you, you do have court tomorrow before your division judge. So as to, we'll do it that way, counts 1, 2, 3, and 7. 1, 2, 3, and 7, you have a $3,500 bond. And on count,
It's $350 each.
on count 11, I'll make it 10,000, you have a $10,000 bond,
Thank you, Judge.
okay? No victim contact and no return to those locations.
Who did we call, Judge?
We didn't.
Okay, then I'm up to speed.
Okay. All right, now we call Zion Hall.
Present at the main jail, Judge. Right there.
All right, Mr. Hall is before the court on a robbery with a firearm charge. It is a first-degree felony, and the court finds probable cause.
Your Honor, the state is going to be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance purposes only, relying upon the arrest warrant affidavit. Your Honor, noting that first there was evidence provided by his co-arrestee, co-defendant, that he he drove him to the location. He was the getaway driver. He provided his co-arrestee with the gun to commit the robbery. This was captured on surveillance. I would also know Mr. Hall, who was on pretrial release on a GPS monitor at the time, the detective contacted pretrial to get the information from his GPS monitor, which places him at the scene, at the time, at the exact location where the robbery was committed. Additionally, it shows that he left the scene in his vehicle the same exact direction that the victim said that the vehicle that the person that robbed him got back into went in that direction. I would also note when law enforcement gained access to the vehicle that the victim said the person that committed the robbery went back to and came from and went back to, Mr. Hall's identification was found in the vehicle, Your Honor. So I do believe there's clearly proof evident or presumption great. I would ask that the court, should you find proof evident or presumption great, that you do not exercise your discretion in setting a bond, noting that he was out on bond and pretrial release of the GPS monitor at the time of this offense for burglary of a dwelling, grand theft of a dwelling, and criminal mischief. If being on a GPS monitor is not enough to deter him from being involved, being a principal to a first-degree punishable by life offense, I don't believe any condition short of being detained in custody can ensure the safety of the community.
Judge, we would object to the court making a finding of proof evident presumption great at this stage of the proceedings, that being the highest standard of proof that we have in our criminal justice system, higher even than proof beyond and to the exclusion of every reasonable doubt. The main evidence against Mr. Hall at this point in time appears to be that the word of a admitted robber who gave a confession to the state, absolved himself of as much blame as possible, said, oh yeah, it was he who gave me the gun. So this is a gentleman who clearly has a motive to misrepresent the truth to law enforcement. There's no positive identification of Mr. Hall by the victim in the case. The other evidence, it relies solely on his ankle monitor, and that is enough, I think, for probable cause. I do not believe that it is enough to establish proof evident presumption great. The fact that his documents were found in that car is really does not mean much. And I think that based on all of this, that probable cause, yes, we would agree. Proof evident presumption great, I would argue to the court that that has not been established here. And I would ask you to set bond for Mr. Hall. If over our objection you find that proof evident presumption great has been established, we would ask you to exercise your discretion and set a bond for Mr. Hall.
And Judge, in furtherance of that argument, I can advise the court that Mr. Hall is a lifetime resident of South Florida. All of his family does reside here. He did attend high school here, obtained a GED, currently working at a car wash. He's advising that he has a daughter who is due to be delivered on September 10th.
And Your Honor, I don't know how much the co-defendant tried to absolve himself. He fully admitted that he committed a robbery with a firearm. And you don't have to go by the ID, go by the GPS monitor that puts his body at that scene.
Judge, you can't infer knowledge by location.
No, but you can infer it by what his co-arrestee said. And why would he admit to committing a robbery with a firearm? He didn't say he didn't have the gun. He didn't say he was just standing by and that Mr. Hall committed the robbery. He said, I committed the robbery with the firearm. What motivation is there at that point to lie about where he got the gun from?
By implicating another person, giving the state attorney another person to prosecute, he can in fact lower his exposure. And so he has a strong motivation to implicate another person.
And also, it was the state's conscious decision not to provide the court with Mr. German's statement today. They could very easily have brought that in for the court to review, and you could make your own determination.
And again, Mr. Reedy can make the same argument over and over, but the court is very familiar with ISAZA and knows the law. I mean, Mr. Reedy knows the Fourth ECA said that is not required.
I didn't say it was required. What I said was it could have been done, and it wasn't. The state has the option to present as much evidence as they would like when they're asking the court to find the highest possible standard of proof that we have. It was Mr. Linder's conscious decision not to provide this court with Mr. German's statement. Instead, we're relying on the testimony of a police officer who witnessed nothing. And again, there's no positive ID of Mr. Hall by the victim in the case. The other evidence is not enough to establish proof evident presumption great.
And again, Mr. Reedy can ask the court to ignore ISAZA essentially all he wants. I would ask the court not to.
I was not asking that. The ISAZA says that the court may find proof evident presumption great based on a probable cause affidavit or an affidavit, that we had an arrest affidavit in this case. It certainly doesn't say that you have to. It's up to the state to again, produce as much evidence as they feel is necessary to establish this very high burden.
All right, at this time, I will not make a finding of proof evident presumption great. Let's make a here as to bond.
Again, Your Honor, if you have found proof evident presumption great, I'd ask that he be held no bond. He's committing a first-degree punishable by life offense while on a GPS monitor for allegedly committing a dangerous offense as classified by the legislature in the state of Florida, a burglary of a home.
Okay. Defense has an argument, Mr. Bond?
Judge, just reiterate that he's strong ties to the community. He does have a job and a child on the way. And we ask the court to set the bond at $5,000.
All right, at this time, I'm gonna set a $150,000 bond.
I'm sorry, what was that number?
150, no victim contact.
Is that 150 or 150,000?
I said $150,000 bond.
Thank you, Judge.
That is going to be with a level 1 GP pretrial.
Thank you.
All right, Joshua Spells.
Present at the main jail and approaching. And I advise Mr. Spells that he has a court date tomorrow in front of his division judge.
All right, Mr. Spells is before the court. 1 and 2, grand theft auto. Number 3, false ID given to a law enforcement officer. 4 and 5, violation of felony probation, no bond hold. Number 6, operating without a valid driver's license. 7 and 8, felony violation of community control. And the court does find probable cause, and
Judge, we're fine with the bonds as set.
I'll leave the bonds in place, okay? Keith King.
Judge, Mr. King is present at the main jail. He is advising that he is not on probation, that his probation terminated on June 26th when he completed a 364-day sentence with probation to automatically terminate. He would like to resolve count 1 and waives an attorney on count 2.
All right, well, does anyone have any information as to his charge, his allegations on 3?
I'm looking it up now. That would appear to be the case, Your Honor.
Okay. So he did, there's no violation of probation.
Does not appear so.
Okay. All right, he wanted to resolve 1. Do you have an offer for that?
Yes, Judge, and he waives an attorney on count 2.
Okay. All right, Mr. King, if you wish to resolve your case today, you'll be sentenced to adjudication, time served on 1. And as to the municipal ordinance violation, I'll dismiss that charge. All right, please raise your right hand. Do you swear or affirm to tell the truth? Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. King, do you understand everything that has been discussed here today?
Yes, ma'am.
And do you understand, do you need any more time to speak with your attorney? Are you under the influence of drugs or alcohol?
No, ma'am.
And sir, you understand you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence as to count 1 is adjudication and time served. And do we need to make a notation as to 3? There shouldn't be a violation to say this is dismissed. And as to number, the VOP is also dismissed, okay?
Thank you, Judge. There is a court date for him tomorrow in FD division. I'd ask the court to delete that from the docket so there's no accidental capias.
Okay. And please delete the hearing for tomorrow.
Thank you, Judge.
Robert McMahon.
He's present and approaching, Judge. While he's approaching, I can advise the court that I did tell Mr. McMahon he has a court date tomorrow in front of his division judge.
All right, Mr. McMahon, you have a KPS, and you will, it's a no bond hold, so you'll see your Judge Casey tomorrow, okay?
Yes. Yes.
Omer Imerk.
He's present, Judge, and approaching.
Go ahead.
All right, Mr. Imerk, you're before the court, charges 1 and 2, aggravated assault on an officer, number 3, unnatural and lascivious act, Number 4, resisting officer without violence. Number 5, fleeing with disregard or safety of persons. And number 6, reckless driving. And the court finds probable cause.
We're requesting a phone order from Mr. Imert.
Okay, I'll sign that order.
Your Honor, I'm asking that the court keep the bonds in place, but that Your Honor also keep at this time, the special release conditions that Judge Tobin Singer set in place.
What was the request, Mr. Linder?
I'm asking that the judge keep the bond and special release conditions that Judge Tobin Singer set in place.
Oh, right.
What are the concerns for the collateralized?
If Your Honor wants to delete that, that's fine, but I would ask that the other conditions be kept in place.
All right, so I'm gonna leave the standard bonds in place, and the conditions, except for the second one that says the defendant shall secure his release by a surety bond that is fully collateralized. I will delete that requirement, okay?
Thank you, Judge.
All right.
Okay, go.
All right, Carlos Garcia Flores.
He's present and approaching, Judge. Do we have a future date for Mr. Garcia Flores?
I don't. It's not what? If it's not on the docket, you don't have it? All right. All right, so Mr. Flores, you're before the court for a violation of probation. That is a no bond hold. You should be going before your division judge shortly. Okay? Scott Price.
Price? Present and approaching, Judge. Mr. Price advises that he has private counsel.
Yeah, after I can reach him, yes, again.
All right, Mr. Price, you're before the court for possession of alprazolam. Number 2 is possession of controlled substance without a prescription. Number 3 is a felony violation of probation, which has a no bond hold. Sir, I find probable cause. You do have court tomorrow before your division judge. So at this time, I'll leave the standard bonds in place on 1 and 2, which are $1,000 each. And as I said before, number 3 is a no bond hold, okay? All right.
Okay.
Adam
Thank you.
Afwork.
He's present at the main jail. One moment, Judge.
All right, sir, you are before the court for, charge 1 is petty theft. Number 2 is false owner info for pawn items. And number 3 is dealing in stolen property, and the court finds probable cause.
Judge, Mr. Afwork is a lifetime resident of South Florida. He works as a delivery driver for Postmates. He lives with his parents. All of his family reside in and around South Florida. This is his first arrest. He cannot afford bond, and we're requesting pretrial release.
Yeah, it's not his first arrest, but I don't have an objection to pretrial, though.
Okay. All right, sir, I'll release you to pretrial supervision. The attorney will give you the information for the pretrial office. You must report within 24 hours of your release. Failure to do so, a warrant will be issued for your arrest. Do you understand that, sir?
Say that again?
I understand.
All right, sir, good luck.
Thanks, Judge. Off you go.
James Toussaint.
He's present at the main jail, Judge. He's proceeding pro se this morning.
All right, Mr. Toussaint, you're before the court. Charge 1 is possession of cannabis, 20 grams or less. Number 2, driving while license suspended. Number 3, 4, 5, 6, 7, and 8 are violation of probations, and those are no bond holds. You do have court tomorrow before your division judge. I find probable cause, and the bond on count 2 will remain at $750. Good luck, sir.
Yes, ma'am, thank you very much.
Gabelin Filsami.
He's in North Broward, Judge, but he refused to come.
Okay.
And he's also on our second look docket this afternoon. He's indicated that he will refuse to attend this afternoon as well.
All right, so Mr. Filsaime does have possession of drug paraphernalia, trespassing and tampering with or fabricating physical evidence. At this time, based on his refusal, this is his second time refusing. The court finds probable cause in absentia. His bond on 3 is $1,000.
And can we delete him from this afternoon?
And please delete him from the afternoon docket. Thank you. Jonathan Rodisek, is
believe
that
he's a
a
medical
medical
loan.
loan?
Yes, Judge.
Medical
Oh,
loan.
that's what I'm told.
And then Jordan Cheeseborough.
Conti.
He's out to court.
He's being arraigned this morning.
Mr. Cheeseborough is in court, so we'll have to reset him. All right. All right. Thank you, everyone. Mr. Millers, good to see you.
Yes. Nice to see you, Judge.
All right.
1:30?
Under that bright light there, that haircut is like.
That's a haircut?
I don't
didn't
know.
see any hair
Is
at
it
all.
I like it. Dale's looking very Walter White dude.
I know.
In
All
that
right.
light.
See everyone this
You
afternoon.
just need the hat and the sunglasses.